Professor Gerald Bamberger. Today we're going to be discussing a problem in the area of constitutional law. It's a multi-state bar examination type of problem. You can find it on my website, www.profbamberger.com. It's problem ConLaw1. If you haven't already worked the problem, why don't you take a moment, pause the presentation, go over to www.profbamberger.com, work problem ConLaw1. It should take you about 1 minute and 45 seconds, and then return to resume this presentation. Okay, I'm going to assume you've already worked problem ConLaw1 on www.profbamberger.com. The correct answer to that problem is choice D. Choice D, the misery procedure violates equal protection because different tally teams may evaluate similar vote cards in different ways. What you have here is a procedure very similar to the procedure that was used in the 2000 presidential election in the state of Florida. The procedure is vote cards are manually being evaluated by different teams. The different teams aren't subject to uniform standards. So what might happen here is that the same card might be interpreted differently by two different teams. With respect to the 2000 presidential election, let's take a look at the Nowak and Rotunda Hornbook, 7th edition, for on constitutional law, for a short discussion on the Bush versus Gore case. I'm just going to read one paragraph at page 999. The Bush III opinion found that once a state legislature gave individuals the right to vote for a government office in general, or for electors for the presidency in particular, the right to vote as the legislature has prescribed is fundamental, and one source of its fundamental nature lies in the equal weight accorded to each vote and the equal dignity owed to each voter. What Bush versus Gore stood for was the idea that in a presidential election, as in any election, if the state government is giving the voters a right to vote, the right to vote being fundamental, is protected under the 14th Amendment by the doctrine of equal protection. If the cards are not subject to uniform standards of interpretation, then the same card may be interpreted differently by two different tally teams. The result would be a denial of equal protection. That's why the correct answer is D. Let's take a moment and examine the incorrect answers, A, B, and C. Choice A says, certiorari was improvidently granted because principles of federalism dictate that procedures for state elections be left to the state. Based on the excerpt we just read in the Nowak and Rotunda Hornbook, it should be clear that the fundamental right to vote applies to all elections when a state provides the voters the right to vote. It doesn't matter whether they're voting for electors in a presidential election or whether they're voting for governors in a state election. The right to vote is protected by the Equal Protection Clause of the 14th Amendment. It's a fundamental right. So there is no distinction between the state election and the presidential election. Choice B, the misery procedure violates the 15th Amendment. The 15th Amendment's a popular trap. Why? Most students recognize the 15th Amendment has something to do with voting. Most students will recall that. Most students, however, won't know exactly what the 15th Amendment has to do with voting. So when they see an equal protection type of question with a voting issue, they will reach for the 15th Amendment, and generally that's incorrect. Let's look at the text of the 15th Amendment. 15th Amendment. The right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. The 15th Amendment is one of the three civil rights amendments, the 13th, 14th, and 15th. The 14th has a very wide range of applicability. It's the home of equal protection and due process. The range of the 13th and the 15th is more narrowly focused on race, color, previous condition of servitude. Here we have the 15th Amendment, which restricts states in their ability to restrict the right to vote based on race, color, or previous condition of servitude. That doesn't apply here. Here the issue is the fact that different tally teams may come up with a different interpretation of the same vote card. So there's no issue of race, color, or previous condition of servitude. Choice B is the wrong answer. Finally, let's take a look at choice C. Choice C says the case presents a non-justiciable political question. Now, some students, whenever they see a political issue, and clearly we have a political issue in this question, a political issue, however, does not make for a political question. A political question is a specific type of issue for which the Supreme Court is unable to find judicially discoverable standards. For example, the Republican form of government clause of Article 4, Section 4. The other way a question can be a political question is if the court finds that the issue has been textually committed to another branch of government. For example, impeachment proceedings are textually committed to Congress by the Constitution. The court won't intervene. That's a political question. This, in contrast, is an issue that is political. However, it is not a political question, as the Supreme Court uses that term. Why? This is a straightforward equal protection issue. It hinges on the fundamental right to vote, for which there are judicially discoverable standards, and clearly the Supreme Court is the correct arbiter of these issues. So the court will entertain this issue. It is justiciable. It is not a political question.